Can a child's testimony decide the fate of a case? Are their words as reliable as those of an adult? Let's find out in this video. Hi, I am Rohit Rohila, and today I'll be discussing law relating to testimony of child witness. I will also be referring to some of the landmark judgments that have shaped the law in this subject. And lastly, we will see some guidelines that are passed recently by the Supreme Court in this regard. But before we do all of that, let's understand the meaning of the word witness itself. Interestingly, the word witness has not been defined in Indian Evidence Act or the Bharatiya Sakshya Adhiniyam, but we may refer to an old decision where this meaning has been provided. That is Shivraj versus State, AIR 1964, Allahabad 290. AIR 1964, Allahabad 290. In this case, the court held that though the meaning of the word is not provided, but after examining the provisions of Indian Evidence Act, it was held by the court that witness can be understood as referring to a person who testifies before the court. This is a very important definition. It looks simple. It looks simple, but carries a lot of weight. Let's consider Section 160 CRPC for a moment, which has now become Section 179 of BNSS. It enables a police officer to call a witness before him and refers to witness as a person who is acquainted with the facts and circumstances of the case. Then Section 161 CRPC, which is now 180 of BNSS, provides that such a witness can be examined by the police officer, and the statements given during the course of this examination can be recorded in writing or through audio, video, electronic means. However, in the light of the definition given in Shivraj versus State of UP, Shivraj versus UP, Shivraj versus State, Shivraj versus State, AIR 1964, Allahabad 290. In the light of this definition, it is clear that the person examined by the police and giving statements to the police during the course of such examination cannot be a witness for the purpose of law of evidence because he is not testifying before the court at this stage. Right? In order to qualify as a witness for the purposes of Indian Evidence Act and Bharatiya Sakshya Adhiniyam, the person has to testify before the court of law. In this regard, you may note down two other decisions from the Supreme Court. Omkar Namdev Jadhav versus Second Additional Sessions Judge Buldana, AIR 1997 Supreme Court 331. And another one is Ram Swaroop versus State of Rajasthan, AIR 2004 Supreme Court 2943. 2943. Apart from this, there are two other legal requirements that are required to be fulfilled to qualify as a witness. Let's discuss each one of them one by one. The first one is the person must be competent to testify. He must be competent to give evidence. For this, we need to refer to Section 124 of Bharatiya Sakshya Adhiniyam. 124 of Bharatiya Sakshya Adhiniyam, which was earlier 118 of Indian Evidence Act. Let's see. 124. See, 124 titled as Who May Testify. It states that all persons shall be competent to testify unless the court considers that they are prevented from understanding the questions put to them or giving rational answers to those questions by tender years, etc., etc. And then the explanation provides that a person of unsound mind is not incompetent to testify unless he is prevented by his unsoundness from understanding the questions and giving rational answers to them. Under this provision, 124 BSA, which was earlier 118 of Indian Evidence Act, the presumption is that every person is competent to testify, and the burden of proof will be on that party which alleges that a particular witness is incompetent to testify. In volume 2 of Sarkar's Law of Evidence at page 1806, you will find an observation that competency is the rule and incompetency is the exception. Right? So if you refer to these initial words from the section, all persons shall be competent to testify, right? It is actually giving that sort of presumption that every person will be deemed to be competent, right? Burden of proof lies on the other person to prove otherwise. Then let's see section 124 again. All persons shall be competent unless the court considers that they are prevented from understanding the questions put to them or from giving rational answers to those questions, right? The section says that a person will be incompetent only when he is not capable of understanding the question or not capable of giving rational answers to those questions. So the tests laid down by this section are the tests of comprehension and communication. If a person is able to comprehend and communicate, that person will be competent to testify. No other test of incompetency has been provided under section 124. Here we can also refer to the next section 125, which deals with witnesses who are unable to communicate verbally. Right? It provides that a witness who is unable to communicate so and so, in which he can make it intelligible or by writing or by signs, but such writing must be written so and so, shall be deemed to be oral evidence, right? A person who is not able to communicate verbally, but who is able to make it intelligible through writing or signs, but the same will be considered, but the same will be deemed to be an oral evidence. So 125 lays down the test of intelligibility. 124 lays down the test of communication and comprehension, right? Right. The next aspect is the aspect of oath. I've told you that there are two essential requirements, right? One is that the person must be competent to testify. We have seen section 124. The next issue is whether the person is competent to take oath or not. You see, the witness has to go, any witness has to go through two stages before giving evidence. First is the competency, general competency, which we have just discussed, 124. He must be able to understand the questions and must be able to provide rational answers to those questions. This is the general prerequisite to qualify as a witness. The second requirement is the person must speak the truth and nothing but the truth before the court, because that is one pillar on which the administration of justice actually depends. So in order to ensure that, oath is viewed as a moral check on the witness, and then a sanction in the form of punishment is provided for perjury in case the witness testifies with willful falsehood. Right? So the after answering the question of general competency, the next question that arises is whether the person is competent to take oath or not. And this question becomes particularly relevant in the context of child witness, because a child might have general competency. He might understand the questions. He might be able to provide rational answers to them. But whether he has that mental capacity to appreciate the purpose of oath and to feel obligated to speak the truth, that is a different aspect. That is a different issue, right? In this regard, we can refer to Oaths Act 1969, Section 4, particularly its proviso. Let's see what is provided. Oaths Act 1969, Section 4, proviso. Let's read it from subsection 1 itself. Oaths or affirmations shall be made by the following persons: all witnesses, that is to say, all persons who may lawfully be examined or give or be required to give evidence by or before any court, or person having by law or consent of parties authority to examine such persons or to receive evidence. Now come to proviso. Provided that where the witness is a child under 12 years of age and the court or person having authority to examine such witness is of opinion that though the witness understands the duty of speaking the truth, he does not understand the nature of an oath or affirmation. The foregoing provisions of this section and provisions of section 5 shall not apply to such witness, which means in such a situation, oath or affirmation shall not be made by such a person, right? But in any case, we'll come to the later part. Just give me few more minutes and then we'll come to the later part of the proviso. So here, the first part of the proviso is providing the discretion to the court that if the court thinks in case of a child under 12 years of age, right? If he is more than 12 years of age, subsection 1 has to be followed. Oath has to be administered. If he is below 12 years of age and court forms the opinion that though he has the ability to speak the truth, but he does not understand the nature of an oath or affirmation. See, here it is provided. He does not understand the nature of an oath or affirmation, then the court can dispense with the requirement of administering him the oath. But then, will it affect the admissibility of such a witness? We have seen that to be a competent witness, to be able to testify, he has to undergo two steps, through two processes. First is general competency. Second is ability to take oath. So what will happen in case of a person who is below 12 years of age? Right? Now let's see the latter part of proviso. But in any such case, the absence of an oath or affirmation shall not render inadmissible any evidence given by such witness, nor affect the obligation of the witness to state the truth. So, despite the fact that a person is not administered oath due to his tender age, right, under the proviso to subsection 1 of section 4 of Oaths Act, despite that, the testimony is not inadmissible. It remains admissible. Right? Admissibility of the testimony will not be affected by this fact only, that the court formed the opinion that oath need not be administered to a person who is below 12 years of age. Right? So for those who are above 12 years of age, the problem will not arise. The oath problem will only arise if the person is below 12 years of age, but the proviso saves the admissibility of such a testimony, even in such cases, right? Now, after the aspect of admissibility, the issue that will come for consideration is reliability, right? We'll discuss it under several heads. The next part of the discussion is divided into several heads, which will highlight the approach of the courts when it comes to reliability of child witness. But before we do that, let me just briefly discuss the aspect of cross-examination. When a witness is examined, the opposite party gets the right to cross-examine him. And cross-examination is the acid test where the veracity or truthfulness or otherwise of the witness is established. And this aspect of cross-examination will become relevant as our discussion will proceed. Right? So keep this thing in mind. Now let's discuss the reliability of child witness. Right? We have seen that every person is competent to testify before the court. The presumption is with respect to competency. There is no age limit prescribed by the Evidence Act or the BSA, right? Every person, whether young or old, is competent to testify, provided he is able to understand the questions and providing rational answers to them. So tender age or very old age will not per se be a limitation, right? It will not disqualify a person from testifying. So a child is a competent witness, that much is clear. Then we have also seen the aspect related to oath. So admissibility is also protected. Now let's see reliability. Before we discuss the reliability in several heads, I would just like to mention one case before you. It was Justice Arijit Pasayat who decided it. Mohammad Kalam versus State of Bihar, 2008, Volume 7, SCC 257. In this case, the court basically it highlights the approach as to how the child testimony must be proceeded with, right? The Supreme Court in this case has held that outright rejection should not be there in case of child testimony. In case of testimony given by a child witness, the testimony should not be rejected outrightly, but at the same time, it must be accepted with caution. Why? Because a child is susceptible to tutoring and is amenable to the views of the others, right? उनको आप ट्यूटर कर सकते हैं, उनको आप समझा सकते हैं, बहला सकते हैं, फुसला सकते हैं. So the approach should be cautious, right? Now let's take several heads one by one, which are important when we prepare this topic for the purpose of examination and even otherwise. The first is duty to conduct preliminary examination. The first head is duty to conduct preliminary examination. In Pradeep versus State of Haryana, 2023 Supreme Court Online SCC Online SC 777. Pradeep versus State of Haryana, 2023 SCC Online Supreme Court 777. It was held that the Supreme Court held that it is the duty of the trial court judge to conduct a preliminary inquiry, to conduct a preliminary examination before recording the testimony of a child witness to ensure whether he is capable of understanding the questions or not, whether he is capable of providing rational answers to those questions or not. The court also held that the opinion formed by a trial court judge in this regard must also be recorded along with the reasons as to why such an opinion was entertained. Also, the questions that were put during the course of this preliminary examination, they are also to be recorded. Why? Because then the appellate court will be in a position to go into these aspects to determine whether the trial court judge entertained the opinion in a correct way or not, right? So it is the duty of the trial court judge to conduct this preliminary examination. Then the next head is whether there is a need for corroboration or not. When a child witness is giving the testimony, should we always look for corroboration or can we solely rely on such a testimony? What is the law? The first case that you can make note of is Dattu Ram Rao versus State of Maharashtra, 1997, Volume 5 SCC, page 341. In this case, it was observed by the Supreme Court that as a rule of law, the corroboration is not required in case of testimony of a child witness. But as a matter of prudence, the courts always look for corroboration. Then in the case of Surya Narayan versus State of Karnataka, 2001, Volume 9 SCC 129, it was held that if the child has stood the test of cross-examination, right? I've told you that cross-examination, this aspect of cross-examination will become relevant when, as our discussion will continue. So here the court has said when a child witness has stood the test of cross-examination, which is, we have discussed the acid test to establish the veracity or authenticity of the testimony or truthfulness of it, right? If the same is done, then there is no harm in relying on the sole testimony of such a witness. Then there is no need to look for corroboration if it inspires the confidence of the court, right? On the similar lines, another case was decided, Rajkumar versus State of MP. This was 2014, Volume 5 SCC, page 353. And I'll read what was held by the Supreme Court. That the law on this issue, on the issue of what? The issue of corroboration. On the issue can be summarized to the effect that the deposition of a child witness may require corroboration, but in case his deposition inspires the confidence of the court, then the same can be relied upon by the court in a given case, right? So the principle is that the law does not say that it should be corroborated by some other independent piece of evidence, but as a matter of caution. Why? Why as a matter of caution? Because as highlighted by Justice Arijit Pasayat in the case that we made note of, that they are the child is susceptible to tutoring and amenable to the views of the others, right? So as a matter of caution, courts, they can insist upon corroboration, but if his testimony inspires confidence, especially when the same is put through cross-examination and it has stood test of such cross-examination, then there is no harm in relying upon it and dispensing with the need of corroboration. The next head is when the court finds that the testimony of a child witness is partly tutored. So the next is partly tutored. When the court finds that the testimony of child witness is partly tutored. In such a case, if the tutored part can be separated from untutored part, and the untutored part inspires confidence of the court, then the untutored part can be relied upon. The same was held in the case of State of MP versus Ramesh, 2011, Volume 4 SCC 786. It was held that in such an eventuality where the court finds that a part of testimony of a child witness is tutored, then if separation is possible, if it is separable from the untutored part, then the untutored part can be considered at least for corroboration. The next head is minor inconsistency. What will happen when the testimony of a child witness is slightly inconsistent, right? In this regard, the law is well settled that minor inconsistencies will not affect the weight of the evidence, the weight of the testimony. The same was held in Ratan Singh, Dalsukh Bhai Nayak versus State of Gujarat, 2004, Volume 1 SCC, page number 64. So minor inconsistencies can be ignored. Then the effect of delay. The next head is effect of delay in recording child's statement at the stage of investigation. And this head was one of the important issues before the Supreme Court, the latest judgment that we will be discussing right after this, right? There was a delay in recording the testimony of the child, the statement of the child during the investigation. So effect of delay, what will be the effect? So there cannot be a straightjacket formula for this, that in case of every delay, the child testimony will not be considered. Such a preposition cannot be laid down. At the same time, we cannot rule out the complete possibility that the child was not tutored, right? So in such situations, the court will look for evidences which will indicate that there are chances that the child was tutored, that there are chances of the foul play on the part of the investigating authority, right? Or the person who has reported the crime, right? If such an evidence is before the court, then the delay can be prejudicial to the accused, and the court will definitely not take into consideration such a testimony. But if such a situation is not there, just because of delay, testimony of child witness will not be shied away, right? Please note this case, Ranbir and others versus State of Punjab, 1973, Volume 2 SCC 444. Volume 2 SCC 444. It was observed that the factum of delay must be put to the investigating officer so that he is in a position to explain the delay. And if the delay is explained, then the court will not take into consideration the delay for the purpose of not taking into consideration the testimony, right? But if the delay is not explained, or otherwise there is evidence before the court, material before the court, which is indicative of the fact that there is some unfair practice that was involved in the case before it, then the court will not support the prosecution's case, right? With this, we come to the last part of our discussion, which is the latest judgment rendered by Honorable Supreme Court on 24th February 2025, just few days back, in the matter of State of MP versus Balveer Singh. So what happened in this case? The accused, there was a case against the accused that he had killed his wife, and when he did the act, the daughter was present. Trial court convicted the accused, but the conviction was overturned by the High Court of Madhya Pradesh, stating that there was a delay in recording the statement of the child by the investigating authority, and hence there are chances of tutoring the daughter, and same cannot be relied upon for completing the chain of circumstantial evidences. Right? It was a case based on circumstantial evidences. So the MP High Court overturned the conviction and acquitted the accused. And then state proceeded to the Supreme Court in appeal. So one of the issues before the Supreme Court was the testimony of the daughter and the statement, the effect of delay in recording the statement by the investigating authority, right? So before we go into the decision of the Supreme Court, let's see what directions or how the Supreme Court has summarized the law relating to the testimony of child witnesses. For this, you can refer to para 58 of the judgment. I'll also show you para 58 of the judgment. After discussing the law relating to child witness, right? See, State of MP versus Balveer Singh in para 58. Para 58, the Supreme Court has summarized the law on this subject. Let's see. Para 58. See. The Evidence Act does not prescribe any age for a witness, and as such a child witness is competent witness and his or her evidence cannot be rejected outrightly. We have also discussed the same. Then the court referred to 118 of Evidence Act. Now it is 124 of Bharatiya Sakshi Adhiniyam, right? Before the evidence of the child witness is recorded, a preliminary examination must be conducted by the trial court. We have seen this as well. Then, before the evidence of child witness is recorded, the trial court must record its opinion, satisfaction that the child witness understands the duty of speaking truth and must clearly state why he is of such opinion. This we have also understood. Then all the questions, etc., are to be recorded. Yes. Next important principle is, yes, this one. The trial court must also record the demeanor of child witness during the course of its deposition and cross-examination, and whether the evidence of such child witness is his voluntary expression and not born out of the influence of others, right? This is a concern. We have understood this is a concern with child witness, their testimony, that they can be tutored, right? So the court also has a duty to record the demeanor of such a child. In fact, there is a section 165 of Indian Evidence Act, the corresponding section from Bharatiya Sakshi Adhiniyam I'm not able to recall right now, but you can refer to the same worded on the same lines, right? The court can also put questions to the witness, including the child witness, which are relevant or irrelevant. So for this purpose is to find out whether the person is capable, whether the child is capable of giving the evidence, right? The questions can also be put by the court. There is then there is no requirement or condition that the evidence of child witness must be corroborated before it can be considered. We have seen this, that there is no such requirement in the law, but as a matter of caution, the courts usually look for corroboration. Then, if the evidence of the child explains the relevant events of the crime without improvements or embellishments, which means it is trustworthy, it is inspiring the confidence of the court, the same does not require any corroboration whatsoever. We have already understood that. Corroboration may be insisted as a measure of caution or prudence where the evidence of the child is found to be either tutored or riddled with material discrepancy or contradictions, right? Then we can see improvisations, fabrications. Yes, opportunity of tutoring the child witness in question, right? See, whereby certain foundation facts suggesting as demonstrating the probability that a part of the testimony of the witness might have been tutored have to be established. This may be done either by showing that there was a delay in recording the statement of such witness, or that the presence of such witness was doubtful, or by imputing any motive, etc., etc. However, a mere bald assertion that there is a possibility of the witness in question being tutored is not sufficient, right? So merely making such an assertion will not do the job of the party who is saying that the child witness was tutored. There has to be some material before the court which suggests such a proposition, right? Just by making a bald assertion, this doubt cannot be created in the mind of the court. Then reasonable likelihood has to be there, where foundation facts suggest possibility of tutoring is established to be further proven or cogently substantiated, which means there has to be, the bottom line is there has to be some material to show that the person was actually tutored. Merely because there was a delay in recording his or her statements, we cannot say that the person was tutored. There has to be some material supporting the same. Then, yes, part of the statement, even if tutored, can be relied upon if the tutored part can be separated from the untutored part, in case such remaining untutored or untainted part inspires confidence, right? We have already understood this. So these were the summary principles, right? Principles summarized by the Supreme Court in this regard, in respect of testimony of child witnesses, right? We have already understood all these things. Now let's come back to the facts of this case. I've told you that there was a delay, good delay in recording the statement of the daughter in this case, and due to this delay, the High Court overturned the decision of conviction. But the Supreme Court, after summarizing these principles, has held that though there was a delay, and delay can lead to tutoring, but there has to be some material supporting such a claim. There cannot be just a bald assertion, and we cannot, just on the basis of such an assertion, we cannot take away this testimony from such a testimony from consideration, right? So the High Court's decision was overturned, and the father was convicted again by the Supreme Court, right? The case is also relevant on Section 106 of Indian Evidence Act, which lays down the burden of proof on a person who is under the special circumstance, who was under the special circumstance when a particular fact was transacted, and it could be in his or her own knowledge, right? Then the burden to prove the same has to be on his or her shoulders. So this case can also be read for that particular section. So as far as child's testimony is concerned, the law surrounding it is concerned, this much is sufficient for you for the purposes of handling any kind of questions that comes from this area. And if you have found this session informative, kindly share it with your friends and peers. Please subscribe, like, and comment. And I'll meet you in more such informative sessions. And if you are looking for a guided preparation for judicial services examination, you can check out the JSEP course provided by LiveLaw, where you will be taught by very experienced faculties, including High Court judges. That's all from my side. Thank you very much. Take care, and we'll meet again.